Here's the facts of the case. Defendant commits a series of 4 burglaries on 4 dates over a 27-day period. Now, that would never happen in New Jersey, but let's just make believe, all right, that it occurred in Middlesex County. He pleads guilty to several indictable offenses on 1 date and is sentenced for all offenses simultaneously. Questions: to what extent does the crime spree exception established in State v. Fontana apply? Or, excuse me, survive the post-code decision in State v. Ross. So Fontana is a 1976 Appellate Division decision, pre-code. Starting point for the code is September 1st, 1979, kind of exactly the same time that letter was written. And the Ross case, State v. Robert Ross, 2008. This case sound familiar to you?
Oh, yeah, we've talked about these 2 cases.
But I mean the facts of this particular case.
Sure, I handled it.
All right, well then grab a microphone and tell everybody what happened.
This was the matter of MG. The fact pattern is as you see it in the first paragraph here. The prosecutor...
Can I stop you for a second?
Sure.
Because I think you've just inadvertently raised a very important point. Just by saying the name of the case, you raised a good point. And I want to ask you a question. It seems to me when you undertake one of these issues and you're going to litigate it, you may get your expungement, you may not get your expungement. But I think in order to prevent your client from having any additional embarrassment or pain associated with having a published case under his name, you should probably be petitioning the court initially to be able to allow the caption to be under the initials of your client as opposed to your client's name. Do you agree with that?
Well, initially, probably not, because in the law division, you're not going to get it's extremely unlikely you're going to get a published decision, and I don't know whether the court would file it if you don't give the name.
Right.
I mean, obviously, you got to give the name somewhere.
Oh, sure.
So they know who it is. Now, I have a case right now. It was in Hunterdon County, and the problem is what you see on this very first page, crime spree. They talk about the State versus Fontana matter, 1976, and Fontana wound up getting his expungement, but his name is emblazoned forever in history because the opinion gave his name.
Or conversely, a case we're going to talk about, State versus Labasso, decided by the Appellate Division a week or so ago. This guy lost, okay? And, you know, had he known that his name was going to be publicized for the rest of eternity in a published decision, he wouldn't have undertaken this in the first place. He's just given himself more publicity about his, his criminal conviction for everybody in the world to see, whereas before it would have been subject to a much smaller audience.
So what happens is, right now I have a case. It was heard in Hunterdon County, and the prosecutor raised objections which the judge ultimately upheld. It's going up to the Appellate Division. It's a very interesting issue that we may very well cover this evening. But what I found from doing appeals is that the Appellate Division encaptions the case in the same caption as the final order, regardless of how it was originally filed. So we knew when we were arguing this case in the law division that it was going to go up to the appellate division. Whoever lost was going to take it up. So I said to the judge, Judge, by the way, if we prevail on this, I would like to submit a new order that references only my client's initials. And if the state prevails and the state draws the order or the court draws the order, can we have it reference only the initials? Incredibly, the prosecutor objected. I mean, it seemed to me to be a very mean-spirited issue, but the prosecutor objected. We had some colloquy on that, and the judge ultimately granted that application. So the final order is State of New Jersey versus DLC. Now it's on appeal. There were 2 issues that we argued in the law division, but I'm having a 3-point brief in the appellate division. The 3rd point is this should be referenced only by initials, because the case law is is very inconsistent in this. Some people get the expungement, it gives their full name. Some people get the expungement, the opinion gives only their initials. Some people don't get the expungement, but it gives only their initials. So it's a very real issue that you want to be...
you really got to be sensitized to this, guys, and work on the judge so that, because I wasn't really sure how you would do it, but I guess you get an order from the law division before the case, once there's a final determination on the case.
The order...
That would change the caption on it, basically.
The judge acceded to my request, and
right.
The final order just had the initials.
Please be sensitive to that, guys, when you're doing this, and take that into consideration so that there's no more embarrassment or hurt to your client. Before we get started, can you talk a little bit about, A, the crime spree exception generally, and Fontana in particular, so everybody understands what's going on versus the Robert Ross case?
Sure. On expungements, there are limits to what a person can be convicted of in determining whether it can get an expungement. The way it is right now, if you have 2 felony convictions, you cannot get an expungement. If you have more than 3 disorderly persons convictions, you cannot get any of them expunged. So what happened with Fontana is that over a period of approximately 7 or 8 days, he committed burglaries. I believe there were 4 burglaries and 4 thefts associated with them, and he eventually applied for expungement. The prosecutor, of course, objected, and the argument that Fontana made and that the appellate court accepted is that these crimes occurred over a very short period of time. They all involved the same kind of offense, burglary and theft. And the appellate division said, we can liken this as akin to a one-night spree. That's their exact language. And therefore, if they liken it to that, then they're considering it all as one package, one bundle, and therefore Patrick Fontana gets his expungement.
So just so we're all oriented in terms of what the basic law is, from a statutory standpoint, a single criminal episode, assuming that you have enough time that's gone by and it's not a criminal violation that's disqualified automatically by operation of law, and assuming there's no objection from the prosecutor's office on some other spurious grounds, you can expunge a single criminal violation, crime, 4th degree and higher, okay? You can expunge a crime assuming that you have no more than 2 additional disorderly persons convictions. But remember, you're only able to expunge the crime under those circumstances, not the disorderly person offenses. If you have more than 2, then you can't expunge anything. On the disorderly persons side, you can expunge as many as 3 discrete disorderly persons offenses within your lifetime. Okay? These are just kind of basic rules. Now, the crime spree exception in the Fontana case happened with discrete individual offenses occurring over, I think it was an 8-day period. Contrast that, I want to just throw this out to you, a guy that has a single episode, and arising out of that episode, he may have convictions involving 1 crime and 2 or 3 disorderly persons offenses, 1 episode. Okay, let's say it's a motor vehicle stop. So out of the motor vehicle stop comes eluding and resisting arrest and, things of that nature. Under those circumstances, do you think you would qualify to get rid of everything, since it's out of one, not a spree, just 1 incident?
I don't know of any published decision that has ruled on that one way or another. I suspect that the answer is probably yes, at least for the crime, not the disorderly persons. Right. I don't think the 3 or more disorderly persons should be disqualifying, because if you look at the exact wording of the statute, and this will become very important, the exact wording says, who has not been convicted of another 3 more than 2 disorderly persons offenses at different, whether prior or subsequent. And in this case,
it'd be simultaneous.
It's simultaneous. It's neither prior nor subsequent.
So maybe you get everything expunged. Who knows?
Well, it would not hurt to ask.
So let's say a third-degree eluding, and then when he stops the car, the police, he fights with the police, and he has simple assault, or
And he's got some grass in the car.
or he has marijuana, something of that nature. Okay, I would just throw it all in the pot and see what happens. No pun intended, by the way.
I agree.